This is the third in a series on international criminal justice that Chatham House conducts with the Barristers' Chambers of Doughty Street. There's a plethora of events on international criminal law in London these days, but I feel that this series is quite a good one. And today will be no exception, because we really do have some very interesting points from recent developments in international criminal law. Could I just mention we're not under the Chatham House rule, even though we're at Chatham House. You have the bios, I think, of our three speakers, whom I will introduce to you in a moment. Could you turn your mobiles off if you haven't done so? And if there is a fire, that's the fire exit over there. We're starting with a brief look at the two rather lengthy judgments in Lubanga and in Charles Taylor, which have both come out in the last few months. And we have Olympia Bekou here from the University of Nottingham to speak to us on those two judgments. Olympia is actually renowned for her work on the implementation of the Rome Statute on the International Criminal Court in domestic law. I always think of you as implementation. So, Olympia, these two judgments.
Okay, thank you. I'd like to thank very much the organisers for inviting me here today. It's a great pleasure to be here, and I do agree with you. It's one of the best events that we can have in international criminal justice in London. However, I feel as I have drawn the short straw, perhaps, having to read the two judgments, 593 pages in the Lubanga, 2,533 pages in the Taylor judgment, and what's even worse, I only have about 20 minutes to talk about them. Before I begin, I'd like to also say that I'm speaking today in my personal capacity, and my views do not reflect the International Criminal Court in any way. Now, I have decided to focus upon a number of issues that cut across both those two recent decisions. So I would approach them more thematically, mindful of the fact, of course, that these decisions are from two separate international tribunals, the ICC obviously being the permanent and the Special Court being an internationalized hybrid tribunal. I also hope that I will be able to offer you some views from the ground, as I have worked in both the DRC and Sierra Leone. Now, let me just begin by saying that both judgments are important. Lubanga is obviously a landmark decision, simply because it was the first decision to be rendered by the ICC. Taylor is equally important, as it is the most important decision of the Special Court, given that it involved a former head of state. Now, the two judgments have something else in common. They both took an inordinate amount of time to complete. Lubanga took about 6 years, and it took 600 pages of ink, and Taylor took about 4 years to complete. And both, I think, are rather disappointing. When I finished reading the Taylor trial this morning, I thought, is that it? Is this what I'm supposed to do with this now? So let me just look at some of the substantive issues that cut across both judgments. And one that is clearly important for both is the use of child soldiers. I'll start with the Lubanga case. What we had in Lubanga is that the majority actually refused to provide a definition on what constitutes use of child soldiers to actively participate in hostilities. The judgment instead implied that such a decision should be made on a case-by-case basis. I find myself agreeing here with the Judge Odio Benito, the judge who actually rendered a separate and dissenting opinion. And she said in her dissenting opinion that this was the first judgment of the ICC, and considering that this is the key issue of the decision, the use of child soldiers, the court should have taken a bit time a bit more time, and they should have used the opportunity to clarify the remit of the use as this is set out in the statute. Now, another curious point about the Lubanga decision is the use of targeting as a means to determine active participation in hostilities. The court said that the underlying element, and therefore the determinative factor of active participation, is whether the child is exposed to danger as a potential target. Now, I think that this is rather problematic because the court did not make clear what they meant by target. What did the court have in mind? Is it a lawful target as defined under the law of armed conflict, or a target in a more general sense? I have no clue. Now, when it comes to the Taylor judgment, conscripting or enlisting children under the age of 15 was also one of the counts that Taylor had to face. Of course, you may know already that the Special Court has a number of decisions on that matter. In fact, many of these are also cited in the Lubanga case. What is important in that respect in the Taylor judgment is that Taylor has been found guilty of conscripting or enlisting children as aider and abettor. This is quite an interesting fact. Moving on to gender-based crimes. In the Taylor decision, we had 3 counts of sexual violence in the indictment, that is rape and sexual slavery as a crime against humanity, and outrages upon personal dignity as a war crime. As I said already, the trial chamber found him guilty of aiding and abetting, and these crimes basically are quite important because here we have the first time that we have a former head of state being convicted, being responsible for various forms of sexual violence. Now, what is also important in terms of the sexual violence is that the Special Court in Sierra Leone looked at the issues from the contextual element. And they, I think, came to the right conclusion that they couldn't have found sexual violence in the crime of terrorizing the civilian population, because sexual violence is a crime of opportunity and cannot be committed with the intent to cause fear in the civilian population. I think this is the right conclusion. Overall, I think the Taylor judgment represents a milestone in terms of sexual violence, in terms of gender justice, not least because it provides that the leaders can be recognized to be responsible even though they're far away from the theatre of conflict, just by supporting or encouraging sexual violence of others. Now, if I look at the sexual violence issue in the Lubanga decision, I would like to note the failure of the court, the majority, to adopt a position on sexual violence. And we're talking about sexual violence here perpetrated against the child soldiers and in fact coming under the provision of use of child soldiers. I should note that the Special Rapporteur for Children in Armed Conflict had testified before the ICC and had urged the court to include any sexual act perpetrated against child soldiers. However, I'm actually sympathetic towards the court in refusing to consider sexual violence as a constitutive element of using child soldiers. I would, of course, have liked to have seen the criminalization of sexual violence before the ICC, but actually not being introduced through the back door, as it would have been in the Lubanga judgment. So the onus here was with the prosecutor. The charges on sexual violence were dropped. So I think the court reached the right conclusion here by not introducing it. Of course, Judge Odio Benito didn't agree with me, and in her dissenting opinion dealt with the matter. She adopts a more purposive, a more human rights-oriented view, and basically adopts the view that the court is not there simply to decide upon the guilt or innocence, but is also there for the progressive development of the law. And therefore, what is the message that this court is sending out to its victims? If we take a victim-centric approach, perhaps this view of Judge Odio Benito is perhaps more sympathetic. And there have been commentators that have adopted this position. However, as I feel for the victims, I think reaching that conclusion, in my view, would have been deeply problematic from a strictly legal perspective. Primarily because this would have to be used or tied to the targeting question I have already mentioned. And that, in my view, would violate the principle of legality. Now, a few words, moving on to individual criminal responsibility, a few words on a co-perpetration. The Lubanga trial was very much on co-perpetration, on the basis of liability, of Lubanga's liability on co-perpetration. Now, there are two interesting issues, I think, that the court's majority looked at in that respect. First, I think that the majority was right to hold that co-perpetration is established when the individuals are aware that implementing a common plan will result in the commission of the crime, rather than may result, which was the standard applied in prior ICC decisions. Therefore, what they have tried to do here is they suggest that the application of dolus eventualis, which is not the wording of the statute, is not what the statute intended. However, what we saw in Lubanga is the inclusion of this concept of essential contribution as a requirement to establish co-perpetrationship. The majority concluded that this was a necessary element for co-perpetration in order to distinguish from aiding and abetting, so accessorial liability. Now, I know I'm probably going against my legal training here, because as a civil law lawyer I should have agreed with the majority. However, I find myself agreeing with Judge Fulford, who actually produced a separate opinion primarily on this issue. What Judge Fulford argued is that there is no such requirement in the statute, so essential contribution is simply not there. So what he proposed was a simple approach. He calls it a plain text approach, which would be preferable and more in line with the statute. Now, moving on to issues of liability in the Taylor judgment, what I think is quite important is that we have a massive failure of the prosecutor in the special court. The joint criminal enterprise has not been upheld by the trial chamber, and Charles Taylor has been found guilty on all accounts, but only as an aider and abettor. So the judges have rejected the allegations that he participated in a JCE to commit the crimes alleged in the indictment, and moreover, they also said that there was insufficient evidence of command responsibility. So, what have we got? We have Taylor convicted only as an accomplice for these crimes, and explicitly refused to, the court refused to hold him responsible as a principal perpetrator. Now, I suspect this might be something that may be fixed on appeal, but we'll have to wait and see. But at this stage, let me just say that JCE 3, developed by the ICTY, where individuals would be convicted not only of serious crimes that they knew of or intended, but those that were objectively foreseeable to the extent that they belonged to a joint criminal enterprise with others. What we have seen in the special tribunal is that the JCE was charged even when this enterprise was not criminal. So what perhaps the trial chamber has tried to do here is trying to bring it back to the element of criminality. Similar approach perhaps taken in the Lubanga. Now, beyond that, I'd like to move to some other procedural issues and perhaps mention a few words about the prosecution, the OTPs of both cases. We had problems with the prosecution on both the Lubanga and the Taylor judgment. In the Lubanga case, the question of intermediaries has taken an inordinate amount of time and clearly almost led to the dismissal of the case. What you see in the decision is that the Chamber was very, very critical in the use of intermediaries. Large numbers of evidentiary problems could be traced back to the use of an intermediary. Now, I am quite, I suppose, sympathetic to the OTP and the difficulties they have in collecting evidence on the ground. It is incredibly difficult. On the other hand, I consider the collection of evidence to be a clear prosecutorial task, and we can't possibly start outsourcing that task. So I would say that we need some sort of framework of accountability so as to both get the right evidence but also respect the fundamental procedures here. In the Taylor judgment, there have also been criticisms of the prosecution there, but they were slightly of a different nature. There are allegations that the prosecution was paying witnesses to testify, and the fact also that a lot of the prosecutorial evidence has been dismissed and ultimately not upheld in terms of the many claims the prosecution was making in the case is also perhaps testament of the bad quality of the collection of evidence there. Now, I want to move on to issues of sentencing. Very quick note here. We have seen that Taylor was convicted to 50 years of imprisonment. In fact, he's going to be spending this time here in the UK. Some people have already criticized the fact that he has been convicted, found guilty of aiding and abetting, and how can you give him 50 years? It's a very, very lengthy sentence. Now, if you read the sentencing judgment, another 44 pages, by the way, he was found to be in a particular position because of the nature of the crimes and because of the fact that he was a head of state. So, therefore, this position acted against him in a way. And in fact, the Chamber goes, he was a class of his own. So, therefore, despite the fact that some of us think that 50 years is probably a bit too long for aiding and abetting, the judges found that this was the appropriate sentence. Now, in the Lubanga case, we don't have the sentencing judgment yet. The last thing the outgoing prosecutor, Luis Moreno Campos, said just before he left office was to request 30 years. And he said he would be prepared to drop it to 20 if Lubanga makes a public apology and commits himself to work to prevent future crimes. Let's see what happens on that note. Now, finally, I just want to say a couple of words on how the judgments have been received on the ground. The Lubanga case, I think, with indifference in the Congo. Lubanga has been seen as a scapegoat, and his own tribe, the Lendu tribe, they do not want to react because they are waiting the decision in the Katanga and Jungolo case. So the Lendus have this saying, have this proverb. I've been told, before we make fun of other children, we want to know what happens to our own children. That's why they didn't celebrate the conviction of Lubanga. Now, in the case of Taylor, we have to consider the impact of the decision both in Sierra Leone but also in Liberia. Now, in Sierra Leone, I think there has been some frustration because of the impunity gap. Sierra Leone may be at the highest echelons, but the average people on the ground suffered owing to crimes committed by lower indictees who have never, lower criminals, sorry, who have never been indicted. So, needless to say that the average Sierra Leonean has never visited the special court in Sierra Leone, as it is too formal. In Liberia, it's a slightly different story. I think the overall assessment is that it was unenthusiastic or perhaps a hostile reaction, but this is because Taylor, partly Taylor was not charged with his many crimes in Liberia, and he's only been charged for supporting a foreign war, and partly because quite a few Liberians think that Taylor shouldn't have been accountable for his crimes altogether. And I think my 20 minutes are just up, so I think I'm going to stop here.
Thank you so much, Olympia, for having highlighted for us the really interesting issues from those two lengthy judgments in so short a time. Now, because we are going to move on to something completely different, I do want to ask if there are any immediate questions or comments from the floor, and I see one there at the back. And if you wouldn't mind identifying yourself, Chris. I think we don't have, yes, we do have microphones. Thank you.
Yeah. Christopher Hall, Senior Legal Advisor at Amnesty International. Thank you very much for a very interesting presentation. I think that the significance of the Taylor judgment is perhaps far greater. It's not simply that he's the second head of state to have been convicted by an international criminal court, but I think that the concept of aiding and abetting will send a very strong message to Defense Department officials providing assistance to either to government forces or to rebel forces which are committing crimes under international law, and also to people in private companies as well. And I would think 10 years from now, we'll remember the Taylor judgment for the aiding and abetting component rather than the fact that he was the second head of state.
Thank you very much indeed. Yes, next one. Anyone? Otherwise, we will move on, and we can always come back afterwards. I did like your, Olympia, if I may say so, the way you showed how the Lubanga judgment illustrates the different means of interpreting the criminal law provisions. On the one hand, you have a human rights victim-centred approach. On the other hand, you consider whether that approach is compatible with the fairness requirements of criminal justice. And it illustrates it in a number of ways. We're going to move on now, although, as I say, we can return to the question of complementarity in the International Criminal Court and Libya, or in other words, who gets to try Colonel Gaddafi's son. And Stephen Powles is going to talk to us on that. Stephen is from Doughty Street Chambers and is a distinguished defence counsel. Thank you, Stephen.
Thank you, Elizabeth. Firstly, I fully endorse everything Chris said. I think one of the really significant things about the Taylor judgment is this aiding and abetting. Essentially, one of the factors or basis upon which he was convicted was essentially supplying arms to the rebels in Sierra Leone from Liberia in return for blood diamonds. And as Chris says, that sends a really powerful message to private companies, particularly arms dealers who provide arms to people who they know are committing human rights abuses with them. The Taylor judgment, as convicting him on the basis of aiding and abetting for that, is I think, as Chris says, really, really, really powerful. ICC and Complementarity in Libya. February 2011, as I'm sure you all know, the UN Security Council unanimously referred the situation in Libya to the ICC prosecutor for investigation. In May, the prosecutor sought arrest warrants for Colonel Gaddafi, his son Saif Gaddafi, and his right-hand man Abdullah al-Sanusi, all for crimes against humanity. The pre-trial chamber of the ICC accepted the three applications for arrest warrants, and warrants were issued, and in July the registry formally requested Libya to arrest and transfer those three individuals. As I'm sure you all know, October of last year, Colonel Gaddafi killed. In November, shortly after, Saif Gaddafi was captured, and the ICC formally put on notification that he'd been captured. And more recently, in March of this year, al-Sanusi was arrested in Mauritania. In January of this year, the Libyan Prosecutor General commenced an investigation into all three, or the latter two, for serious crimes. Notwithstanding the fact that the Libyan prosecutor had started an investigation, the ICC in March reiterated its request for the transfer and surrender of Saif Gaddafi. Then there was a development in May of this year, because on the 1st of May, the government of Libya sought to challenge the jurisdiction of the ICC pursuant to Article 19, subsection 2 of the ICC statute, on the basis that it was investigating the same case, namely the same individual and the same crimes as were before the ICC. Shortly thereafter, on the 1st of June 2012, the pre-trial chamber formally postponed seeking execution of the request for surrender of Saif Gaddafi, pending the determination of Libya's challenge to the admissibility. So transfer has been postponed pending determination of Libya's challenge to admissibility. The government of Libya bases its challenge to admissibility under Article 19 principally on the basis of complementarity. In short, as I'm sure you all know, the principle of complementarity says that the domestic state has got the first bite of the cherry to prosecute someone. It's one of the core principles at the heart of the ICC statute and at the cornerstone of all of its functions. And Article 17 of the ICC statute says that where a domestic state is either unwilling or unable to prosecute, then only then will the ICC's jurisdiction kick into play. You can look at the statute itself for the formal definition of unwillingness and the formal definition of unable. In short, unwillingness is obviously not prosecuting them or having a sham prosecution to deliberately shield them, and unable is because of, for example, a collapse in a judicial system and an inability to collect and gather evidence for use in prosecuting the person concerned. And the ICC Appeals Chamber said there's a two-step process in determining whether a case is admissible under Articles 19 and 17. Firstly, they say you have to look at whether there exists a national investigation or prosecution relating to the case at hand. So the first step is there an investigation or prosecution? And then the second step is, where such proceedings exist, whether the state is genuinely, and I stress genuinely, whether the state is genuinely willing or able to carry out the investigation and or prosecution. The ICC has reaffirmed that the principle of complementarity applies irrespective of whether the case has been referred to the ICC by the Security Council or whether the state concerned is a state party itself. So even though the Libyan situation has been referred to the ICC by the UN Security Council, this principle of complementarity applies. Libya, under the ICC statute, has the first bite of the cherry. Now, as I said, on the 1st of May 2012, the government of Libya has filed its application challenging the admissibility and of the prosecution of Saif Gaddafi and al-Sanusi before the ICC. They're represented by Professor Philippe Sands, QC, Professor Payam Akavan, a former ICTY prosecutor, and Michelle Butler. I mentioned that just in passing because they're trying to argue that they have the capacity and ability to conduct the prosecution properly in Libya, yet they've instructed not a single counsel from Libya itself and have gone abroad to seek representation, perhaps significant. The government of Libya assert that the national authorities are actively investigating Saif Gaddafi and al-Sanusi. They say they're committed to post-conflict transitional justice and national reconciliation, and they have a genuine willingness to bring them to justice, as they say, in furtherance of building a new and democratic Libya governed by the rule of law. They acknowledge immense post-conflict challenges faced by Libya, but stress that the new government, the National Transitional Council, is committed to restoring stability and improving the human rights situation. They claim to be gradually restoring the judiciary by reopening courts and recalling judges. They also stress the need for national ownership of the trials as a foundation for, as they put it, reconciliation, democracy and the rule of law. The government regards these trials as a matter of the highest national importance so that they can demonstrate that Libyan justice is capable of offering a proper investigation and prosecution and that they can themselves conduct fair trials. If there are any shortcomings in the process, the government of Libya say, don't worry, because we can seek support from the international community to help achieve a fair and balanced process, especially, they say, from specialist UN bodies. So they say, don't worry if there's any shortcomings, we can rely on the international community to help us have a much better criminal justice process. They stress that they have taken real steps so far in investigating Saif Gaddafi and al-Sanusi. They go through and list, although it's redacted in the public document, all the people that they've interviewed. That includes members of Gaddafi's close family, military personnel, and his close associates. They claim to be investigating and prosecuting the case, and claim that the investigation that they're conducting is as clearly into the same persons and for the same conduct that the ICC prosecutor is investigating, or seeks to prosecute Saif Gaddafi and al-Sanusi for. They also refer, interestingly, to the 2011 Libyan constitution, perhaps at this stage untested, and say, well, look, we have this wonderful constitution that has wonderful guarantees enshrined within it relating to independent judiciary, fair trial guarantees, and that obviously people are innocent until proven guilty. They also stress that Libya is a party to the International Covenant on Civil and Political Rights, and claim that because of these bold statements, they can be therefore trusted to apply those statements contained therein. Whether they can or not perhaps remains to be seen. They say in their application that the principle of complementarity requires that states be given the benefit of the doubt in determining whether they can properly conduct an investigation and prosecution. They say that complementarity requires them to be given a pretty wide berth and acceptance in what they say in terms of their ability to do things properly and effectively. They refute that the statute or rules requires proof of a genuine willingness or ability to prosecute, and they say that a simple willingness or ability should suffice. They also say that any party wishing to allege that the government's efforts are not genuine, that party itself bears the responsibility of proving it. In any event, the government says, don't worry because our efforts are genuine, and they refute categorically that Saif Gaddafi has to date been subjected to any physical abuse. They claim that the National Transitional Council and the local authorities in Zintan have gone to extraordinary lengths to protect Saif Gaddafi from violence and vengeance, and that they are fully in favour of a fair trial. Now, that's the government of Libya's position. The prosecutor has responded. They acknowledge fairly that this is the first time that a government has sought to challenge before the ICC a case provided on concrete information detailing that it's prosecuting the same case, namely the same individual and the same crimes. And they said this is quite a significant development. This is the first time that you have the same individual and the same crimes that the domestic state says it is prosecuting. They accept that under the Appeals Chamber's two-limb test, namely that there is a national investigation at hand, they accept that that's in play, but they question the second limb of the Appeals Chamber's test, whether the state is genuinely willing and or able to conduct an investigation and prosecution. And to support that, the prosecutor point to the fact that Saif Gaddafi has not yet had a defence counsel appointed in the national proceedings, and secondly they also point to the strained relations between the NTC and the Zindan militia. Therefore, the prosecution say, before the pre-trial chamber reaches any firm conclusions as to the admissibility of this case, they should accept the government of Libya's offer to receive more evidence, particularly on their ability to advance the case forward in Libya itself. Worryingly, the prosecution say there is no need to analyse the fairness of Libya's criminal justice system. They say that because there's no indication that Libya is trying to shield the suspect. And they say you only need to look at the fairness of domestic proceedings if the government is trying to shield the defendant from prosecution and liability domestically and as a result internationally. They say that as a result of that there's no need to look at the fairness of the proceedings in Libya, and they say moreover, you can rely on the fact that in their application, the government of Libya has articulated all its fair trial guarantees as enshrined in the Constitution and under the ICCPR, and say that it would be that the pre-trial chamber should not embark on a speculative exercise to consider how the rights of the suspect in this case will be respected in the course of proceedings. Notwithstanding that, they said the ICC should monitor proceedings going forward. That's the prosecutor's response. The victims have responded, and they question, like the prosecution, whether the investigation is genuine. They note that the NTC has failed to secure the transfer of Saif Gaddafi from the Zindan brigades into the custody of state authorities. They also point to reports that negotiations have failed between the Zindan fighters and the government, and that the Zindan fighters are concerned that the government will not be able to ensure that Saif Gaddafi will not escape if moved to Tripoli. They stress quite strongly that the victims that they represent favour an international trial and doubt whether national jurisdictions are properly equipped to deal with the serious international crimes at play. Crucially, on the part of the victims, that they feel that the national authorities cannot provide for the safety of victims that may or may not participate in any domestic proceedings. So for that reason, they very firmly support prosecution at the ICC itself. The defence, as far as I understand it, have not filed any formal response yet to the government of Libya's application challenging admissibility. They wanted an opportunity to inspect various documents provided or held by the Libyan authorities before they filed any such response. And obviously, I'm sure you're aware there are developments in Libya at the moment in terms of the defence team that have gone to Libya are currently in detention, making it difficult for them to be in a position to file any response. But I'll say a little bit more about that later if there's time. It seems to me that the main issue for the ICC in this case is whether Saif Gaddafi can have a fair trial in Libya itself. There's no doubt at all that the government of Libya clearly desire to prosecute him and punish him with the highest possible penalty. They're proposing the death penalty for him. The real issue then is whether he's going to have a fair trial as part of that process. It seems to me that should be of concern not just to Saif Gaddafi, but also to his alleged victims, to the prosecutor, and to the international community as a whole. Ultimately, crimes against humanity are crimes that are said to shock the very conscience of humanity. The whole international community, therefore, has a vested interest in ensuring that those responsible for such crimes are held to account, but also that they're held to account fairly and in accordance with the highest international standards. If Saif Gaddafi is ultimately convicted domestically, as it seems he inevitably will be, but if that process is unfair and biased, how can that possibly be said to be justice for the victims? His supporters will inevitably, at the end of such a process, say, well, of course he was convicted. The whole process was fundamentally flawed from the outset. The conviction was inevitable and the outcome obvious. How is that possibly justice for the victims and the people he's alleged to have abused? It seems to me it's as much in their interest as Saif Gaddafi himself that the process is crystal clear and seen to be fair and proper. It's inherent in the concepts of, I would say, the concepts of unwilling and unable, that a state should be required not only to be willing to provide a trial, but willing to provide a fair trial. And it's crucial, I would say, that they not only be able to put someone on trial, but able to give them a fair trial. Now, Article 17, subsection 2 of the ICC statute, in its description of unwillingness and how it sets out how unwillingness should be determined, says that the ICC should have regard to the principles of due process recognised by international law, and that the domestic proceedings must be independent and impartial. So perhaps, in relation to unwillingness, inherent in the statute is a crystal clear indication that the trial should be fair, certainly independent and impartial, and in accordance with the due process recognised by international law. Ironically, in subsection 3 of Article 17, in relation to inability, there's no clear indication that inability requires that the state be required to give a fair trial, and ability is to be determined along the basis of a fair trial as much as anything else. So simply just by asserting they are able to try someone seems to be enough. That's manifestly absurd, because if a state says we can put someone on trial, but they say that they're going to do it, by without giving him defence counsel, without giving him a chance to challenge the evidence against him, of course they might be able to give him a trial, but if it's not a fair trial, it's not a trial that's one that should be recognised by the international community. As I said earlier, questions arise as a result of the detention of the ICC defence team in Libya at the moment. Obviously, they've gone to visit with Saif Gaddafi, and leaving aside the rights and wrongs about anything that may have been done there, the situation highlights some very real concerns about relations, firstly between the Zintan Brigade and the NTC, but crucially, whether Libya is able to properly ensure a fair trial, especially if, as they say, they're going to seek assistance from the international community in ensuring that any trial is fair and proper. If international observers can't go to Libya safely and do their and carry out their responsibilities fearlessly and impartially, without the risk of the Libyan authorities subjecting them to detention or worse maybe, then how can they properly say that we're going to be able to rely on the international community to assist us in ensuring that the trial is going to be fair and proper? More recently, the former ICTY prosecutor Richard Goldstone observed that the detention of the 4 ICC officials is clearly in violation of international law, and he calls it effective kidnapping, and so it demonstrates that there is, as yet, no rule of law in Libya. Just finally, in the last few moments, what will happen if the ICC rejects the government of Libya's challenge to admissibility and says that, notwithstanding the motion, Saif Gaddafi has to be transferred to the ICC? Obviously, state parties to the ICC statute have an obligation to comply with ICC orders. Libya is not a state party and therefore does not have any such obligation. The Libya situation, as I said earlier, was referred by the UN Security Council, but, interestingly, the power conferred on the ICC by that referrer is not the same as the power conferred on the ICTY or the ICTR, which, as you know, were also established by UN Security Council resolutions. The UN Security Council resolution in relation to the ICTY says that all states shall cooperate fully with the ICTY and shall comply with requests and orders issued by the trial chamber. By contrast, and it's a very real contrast, the UN Security Council resolution referring the Libyan situation to the ICC simply says that the Libyan authorities shall cooperate fully and provide any necessary assistance to the ICC. Importantly, while recognising that states not party to the Rome Statute, which of course Libya is not, have no obligation under the statute. The resolution then goes on to simply and only urge all states to cooperate fully with the ICC. So a much lower standard than the Security Council resolutions establishing the ICTY and the ICTR. Possibly then, it's worth thinking about pragmatic alternatives to prosecution at the ICC. There are a number of possibilities. For example, a hybrid tribunal along the lines of the Special Court for Sierra Leone, whereby the government of Libya could enter into an agreement with the United Nations Security Council to set up a hybrid tribunal with a mixture of international judges and local judges and international prosecutors and local prosecutors, similar model in Cambodia. Or, as urged by the government of Libya, the ICC could encourage adoption of positive complementarity, i.e. ensuring that international people have as much involvement in the domestic process as possible to help build national capacity to prosecute international crimes and assist and offer support to domestic prosecutors and judges as part of any domestic prosecution. Again, the arrest and detention of the ICC officials at the moment really raises a question mark over that's practical or viable if international officials are going to be at risk of detention and prosecution if they ever end up in Libya. Finally, and one alternative could be, Libya of course is a party to the international covenants and civil and political rights. One approach may be to urge Libya to grant the right of individual petition under the ICCPR, under the first optional protocol, which would give Saif Gaddafi or anyone in Libya the opportunity to make a complaint to the UN Human Rights Committee if they felt that any of the rights contained within the ICCPR had been violated. And thereby, as a result, there could be some sort of international oversight and scrutiny of domestic proceedings by an international body applying international standards. But that's just one possible alternative. Just by way of closing, in his NSC PhD thesis, Saif Gaddafi, assuming that he wrote it himself, apparently strongly endorsed the need to hold war criminals personally responsible and hold them to account. That's, of course, a laudable aim, but even he, one would have thought, would have expected that any such accountability process be both fair and impartial. For his sake, I would submit, and for the sake, importantly, of his alleged victims, the international community must do all it can to ensure that he receives a fair trial, whether in Libya or the ICC itself.
Thank you very much indeed. And this case does illustrate so vividly this interesting question of whether it is for the ICC to secure a fair trial in national proceedings. We all want everybody to have fair trials. Is it for the ICC in the course of its determination on complementarity to achieve that, Or is it for other international human rights courts, perhaps not applicable here, or for the ICCPR committee? That is the interesting question which the Chamber will have to decide, I think. Any immediate comments or questions in relation to that? Yes, please. Microphone over here. Have we got it?
Thank you. Clive Baldwin, Human Rights Watch. Thank you very much, Stephen, for saying so much in a brief period of time. And I think it's also worth stressing, it's just still a surreal situation when the Libyan government is arguing that it will give a fair trial when it doesn't actually control Saif, was controlled by a militia outside its control. So one effect, if the ICC does rule that it cannot go back to the trial cannot go back to Libya, is that the government in Tripoli will still not be in a position to comply. I was going to ask also, in the government's application, has it also addressed the issue of arbitrary detention as well as the treatment of Saif? Because we've got the situation where, as far as we're aware, he still hasn't been before a judge, so his detention remains illegal and arbitrary. And also that would be impossible or very difficult because he's been held by a militia, so it's outside of Libyan law. And if there was any doubt on that, a new Libyan law will come into force. I think it says on the 1st of July or some date in July that no militias will continue to detain anybody. So have they been addressing that? And you mentioned the constitutional charter. I mean, there has been a recent ruling where the Supreme Court has struck down a law for violating human rights in that. But for some reason, that constitutional charter doesn't give any guarantee on detention and freedom from arbitrary detention.
Thank you.
I'm not sure that they have expressly dealt with arbitrary detention. I can have a look at it again. And what they spend a lot of time on is dealing with his treatment in custody and saying that, of course, he's been well looked after and fed and hasn't been abused, etc., etc. But I'm not sure if they've dealt with the question of arbitrary detention, particularly perhaps, as you say, because they've got no answer to it. So, of course, it's naturally would be something that they wouldn't deal with if it's something that they haven't guaranteed him. It's much more prescriptive in terms of going forward and how they will be able to guarantee him a fair trial going forward, but perhaps doesn't deal with that aspect of things retrospectively in the past.
Thank you, Chris. Just briefly, if you wouldn't mind.
Two quick points. One is with regard to the question of genuineness. I would urge all of you to look at the piece that Jonathan O'Donoghue from our office did in the European Society of International Law blog on the question of whether there is the genuineness includes the concept of fairness and why Article 21.3 necessarily would trump any interpretation with that regard to genuineness. The other is the question of conduct, which I think would be useful to refer to the decision in the Kenya situation, where although they talked about the investigation had to be the same conduct, that would really only be a necessary but not a sufficient ground, because they also noted that they were being the investigations were for trivial offenses, and that was not a crime under international law. And Libya, to this day, has not defined war crimes, crimes against humanity, or genocide as crimes under national law. Yeah. So arguably, they are unable, simply because they failed to define the crimes.
Thank you. Now, we are really scampering through all of these subjects, but we're now going to move to immunities and the International Criminal Court, immunities and other obstacles to cooperation with the International Criminal Court. And here we have Dapo Akande, university lecturer from Oxford, and he also edits the EJIL Talk, which is a brilliant blog in international law and contains many useful discussions on international criminal law. Dapo.
Thank you, Elizabeth. When Elizabeth invited me for this, I noted that the date clashes with the semi-final of the European Championships. And not only did it clash with the semi-finals, if England had reached the semi-finals, there was a potential clash with England reaching with this event. But dare I say it, happily, England did not reach the semi-finals, so we can all be here. Well, There is another match going on, and I am standing between you and that match. I'm going to talk about the ICC and problems of immunity. Let me take you back to the Taylor case, which Olympia was talking about. And we've already noted that one of the significant things in the Taylor case is that this was the conviction of a former head of state by an international tribunal. And of course, Charles Taylor was the head of state at the time when he was indicted back in 2003. The Special Court for Sierra Leone had to deal with the question of immunity early on in 2004. And they held that serving heads of state did not have immunity from prosecution before an international criminal tribunal. Now, in the context of the ICC, the issue of immunity has also been significant. Suffice to note that 3 of the people for whom the ICC has issued arrest warrants were either serving heads of state or former heads of state. So President al-Bashir of Sudan, Colonel Gaddafi of Libya, and Laurent Gbagbo of Côte d'Ivoire, who is a former head of state. And in the context of Darfur, the question of the immunity of the Sudanese President Bashir has been quite significant in contributing to some of the tensions between the International Criminal Court and the African Union. The African Union has insisted that because President Bashir is head of a state that's not a party to the ICC statute, that he's immune from prosecution and also immune from arrest. And the African Union Assembly of Heads of States has issued a series of resolutions in which they've called on members of the African Union not to cooperate with the ICC in relation to the Bashir case. And indeed, a number of African states did fail to arrest Bashir when he traveled to those countries, and this included both states that are parties to the Rome Statute as well as states that are not parties to the Rome Statute. For some time, the ICC ignored this immunity issue in relation to Bashir, and all that the ICC did was the pretrial chamber condemned a couple of African states that had refused to arrest Bashir and reported these states to the Security Council, but it did not specifically address the issue of immunity, which had been raised by the African Union head-on. There was some allusion to this immunity issue in the original decision of the pretrial chamber to issue an arrest warrant for Bashir, but they didn't really spend a lot of time talking about this issue. And let me just start by highlighting a problem actually in relation to how these immunity issues arise in the context of the ICC. The problem that we have is that when the prosecutor makes a request for an arrest warrant, that request is made ex parte. And almost by definition, the prosecutor has no interest in raising the issue of immunity because he's seeking to get an arrest warrant. And so it is conceivable, as has happened, that the issue just doesn't come up at all because only the prosecutor makes representations and the prosecutor has no interest in raising it. Now, it's possible for the accused person to raise the issue of immunity subsequently, but in circumstances where a serving head of state takes the view that the tribunal is acting in some way illegitimately or illegally under international law, the more likely option, as happened in the case of both Libya and Sudan, is that they will simply try to ignore the decision, and so they have no interest themselves in raising it before the tribunal. And in my view, this puts an obligation on the judges to discuss the issue in circumstances where there is a reasonable case that could be made that this is an issue, because that's the only way in which the immunity issue can get aired. And unfortunately, in the case of the ICC, unlike in the case of the Special Court for Sierra Leone, it was an issue that the judges chose to ignore for a couple of years. In December of last year, we finally got a detailed decision from the pretrial chamber of the ICC with respect to this immunity question. But for 2 years, as I say, the ICC just completely ignored it. And this had the unfortunate effect, in my view, of contributing to the tension with the African Union, because African states were of the view that their arguments in relation to this question were simply being ignored. in the case of the Special Court for Sierra Leone, what the court did back in 2004 was that it actually appointed special counsel to deal with this issue. So I think it was Professor Sands, Philippe Sands, and Diane Orentliker were appointed to deal with this issue because, of course, President Taylor was not, as he then was not represented. So as I say, in 2011, in December, the ICC pretrial chamber finally dealt with this issue. And it was dealt with in the context of the failure by the governments of Malawi and Chad to arrest Bashir on occasions when he had visited those countries. The pretrial chamber agreed with the Special Court for Sierra Leone's decision back in 2004. In other words, they also held that serving heads of state do not have immunity from prosecution before international tribunals. And furthermore, they held that that lack of immunity extends to attempts to arrest these serving heads of states at the national level. So not only do they not have immunity before the International Tribunal, states were free to act at the behest of the International Tribunal and to arrest the serving head of state. And the ICC pretrial chamber held that these principles applied even in the case of a head of a state that was not a party to the Rome Statute. I'll come back to this decision later on, but just to say that in my view, it's a very poorly reasoned decision. The effect of the decision is effectively to erase two provisions of the Rome Statute. And the reason that I talked about the process by which these issues are raised before the tribunal is that I think that that has something to do with the fact that the decision of the pretrial chamber is very poorly reasoned. Because the pretrial chamber did not have arguments from counsel. They basically did this on their own. And I think it's very rare to have a decision of a court which is improved by lack of argument from counsel. There ought to have been arguments from counsel. There was absolutely no attempt in this decision to address any of the issues, any of the difficult issues that are raised. Bill Shabas wrote that the decision reads very much like a lawyer's brief. In fact, I think it's worse than that, because no lawyer would ever, I think, write a brief in which they just put forward their side and don't even attempt to engage with the arguments on the other side, which is precisely what the ICC pretrial chamber attempted to do. No attempt at all to engage with the arguments that would be put on the other side. Okay, so what's the key question that has arisen in relation to immunities and the ICC? The key question really is this: to what extent, if any, do international law immunities, the immunities that international law accords to certain state officials, to what extent do they apply in the context of ICC prosecutions? That question arises at two levels, and it's important to remember that that question arises at two levels. It's not one question, it's two. First of all, is there immunity from prosecution by the ICC? Secondly, is there immunity from arrest by national authorities that are acting at the behest of the ICC? Two separate questions, and both are important, because, of course, the ICC, in the context of cooperation, which we've been talking about, requires national authorities to assist in the arrest of suspects before the ICC. So, is the person immune before the ICC? And secondly, is the person immune from arrest before national authorities that are acting at the behest of the ICC? Very quickly, 30 seconds, just to remind you, I'm sure you know, the immunities that international law provides in a domestic context. So if we're talking about prosecutions before domestic courts, international law accords immunities to certain senior serving state officials. So heads of state, heads of government, possibly foreign ministers, have immunity whilst they're in office from prosecution by other domestic tribunals. And this was confirmed by the International Court of Justice in the arrest warrant case. And that immunity before domestic authorities extends even to allegations of having committed international crime. So that's the background that international law provides. What's the position then when we turn to an international tribunal, and what's the position when we turn to the ICC specifically? The ICC statute has two provisions that deal with this question. The first is Article 27, and the second is Article 98. The two provisions on their face appear to be inconsistent, they appear to be contradictory, but let me summarize for you what they say. So Article 27 essentially says, immunities which may attach to the official capacity of a defendant shall not bar the court from exercising jurisdiction. That's Article 27. Article 98, though, goes on to say that the court may not proceed with a request for arrest or surrender, which would require the requested state to act inconsistently with its obligations under international law with respect to immunity. So one provision says immunities shall not bar the court from exercising jurisdiction. The other says, but the court may not proceed with a request or surrender if this would require the requested state to act inconsistently with its obligations regarding immunity. Now, one way of looking at the interplay between these two provisions is to say, well, it goes back to my two questions. Article 27 deals with the issue at the level of prosecution before the court, so no immunity before the court. But then to say Article 98 deals with the second question, what about cases of arrest at the national level at the behest of the court, and that Article 98 preserves that immunity. That's one way of interpreting the interplay between these two provisions. But I think that's not the right way to interpret those two provisions. In my view, Article 27 also removes immunity even at the national level with respect to ICC parties. In other words, when Article 27 says that immunity shall not bar the court from exercising jurisdiction, that provision applies also to the it applies also to the court's ability to request arrest and surrender at the national level, and it also removes the immunities of ICC parties, the immunities of officials of ICC parties. Why do I think that's the best way of interpreting Article 27? Because any other interpretation will deprive Article 27 practically of all meaning. Because the court will only be able to exercise jurisdiction based on an arrest by a national authority in most cases, not all, but in most cases, if immunity is preserved at that national level, you never get to the court being able to exercise jurisdiction under Article 27. And there are other reasons regarding how Article 27 is framed, which I think support that interpretation. So how then do we look at the interplay between the two? So in my view, the best way to interpret the interplay between the two is to say states parties to the ICC have waived whatever international law immunities their officials might have under international law, but Article 98 preserves the immunities of non-state parties. And even independently of whatever the Rome Statute might say, the immunities of non-state parties are rights belonging to those non-state parties. Nothing in the Rome Statute can remove the immunities of non-state parties, whatever the Rome Statute might say, because by definition, they're not bound by the Rome Statute. So nothing, even if Article 27 said no immunities for non-state parties, that would not of itself suffice to remove the immunities of non-state parties. And I think Article 98 is a reflection of that immunity that is accorded to them. The difficulty with this argument, and this is what we have faced in relation to Bashir, is what is the position in relation to a non-state party when the court is dealing with the case as a result of a referral by the Security Council? So it's fine to argue, as I've argued, that non-state parties, the immunities of non-state parties continue to exist, but what about cases of referrals by the Security Council, as happened in Sudan and as happened in Libya? So let me come back to the decision of the ICC pretrial chamber in December of last year. The ICC pretrial chamber in December of last year took what I would call the nuclear option, which is not effectively, what they said is that there is no immunity before international tribunals at all. Not even no immunity before international tribunals for international crimes, no immunity before international tribunals at all. And And they referred to a list of provisions with regard to previous international tribunals which, in their view, support this conclusion. I indicated earlier that I think this is a very weak decision because this list, this lengthy list that they refer to, they failed to take into account two things in relation to that lengthy list. First of all, the provisions that they refer to are not strictly speaking provisions on immunity. They're provisions that say official capacity of a defendant does not exclude criminal responsibility, which of course is correct. But that's not to say that that particular defendant is not immune from the jurisdiction of a particular tribunal. Secondly, they failed to note that with respect to the Nuremberg Tribunal, the ICTY, the ICTR, these instruments that they refer to the extent that they do remove immunity, are binding on the relevant states. In other words, these are instruments which, if they remove immunity, have legal force with respect to the particular states whose immunity has been removed. If we go back to the position that says the immunities of state officials is a right which belongs to states, then there's a simple treaty law question about whether that immunity can be removed by a treaty to which those states are not parties. And as I said earlier, the answer to that under treaty law is no. The argument that the pretrial chamber puts with respect to this view that there is no immunity before international tribunals, but there may be before national courts, is to say, well, immunity is intended to prevent states from interfering in the affairs of other states. That's the reason why we have immunity. The reason why one state cannot arrest and put on trial the head of state of another state is to prevent one state from interfering with the affairs of another state. But they go on to say, well, but this doesn't apply in the case of international tribunals because international tribunals are obviously independent and they are not acting at the behest of particular states. The problem with this argument is that international tribunals are established by states. And this argument suggests that what one state may not do individually, it can do in cooperation with 2 or 3, maybe 4, maybe 15 other states. What struck me actually in reading that decision is that at the moment the African Union is discussing the extension of the jurisdiction of the African Court of Human Rights to include criminal cases. And on the view of the ICC pretrial chamber, it would be perfectly legitimate for the African Court of Human Rights to make this jurisdiction universal, to apply to foreign heads of state, and that would be fine because it would be an international tribunal. One of the problems, of course, is we don't have a definition in the decision of what an international tribunal is. But presumably, what they're saying is it's a tribunal created by an international instrument, and that suffices. The reason, and I'll close here, the reason that I think the decision of the pretrial chamber is unfortunate, quite apart from the process, is because I think they need not have gone down the nuclear route. There is another option, which is much more plausible. I actually agree with their conclusion that President Bashir does not have immunity. The other option would have been to say that because the case was referred, the situation, was referred to the ICC by the Security Council, the Security Council has in effect conferred jurisdiction on the ICC in accordance with the statute. Sudan is obliged to accept that jurisdiction. And on the basis of the Security Council resolution, Sudan is bound by the provisions of the statute, including Article 27, which is the provision that removes immunity. Let me stop there.
Thank you very much. I blame it all on Philippe Sands, who was the amicus in the Special Tribunal for Sierra Leone, which said, as you mentioned, that there is no immunity before international courts. Leaving aside the question whether the Special Court is an international court, and leaving aside the treaty questions that you've discussed. Right, let's now open it up for discussion either on the immunities question or on any other matter that we have been discussing this evening. And after this, there is drinks upstairs. Don't let that influence you. Yes, please. Can we have a mic here, please, if you wouldn't mind being Speedy, thank you.
Hi, my name's Josh Kern. I'm from BCL Burton Copeland. I was very interested to hear Stephen Powles compare the language of the Security Council resolution urging the states to cooperate with the International Criminal Court vis-à-vis the language establishing the ad hoc tribunals, which is, I think I'm right in saying, more mandatory.
Shall.
Right. And I was just wondering whether in Mr. Akande's view, that language would impact at all on whether a state party would be obliged to, a non-state party into which, whose jurisdiction someone protected by immunity were to visit, would be under any more obligation to cooperate with the International Criminal Court than they would with any of the ad hoc tribunals. And if Mr. Powles has a view on that too, I'd be very interested.
Thank you very much, because that was the last sentence that you didn't say, Dapo. You said that the alternative route was that President al-Bashir wouldn't have immunity because of Article 27, but what about the non-state party who is only urged by the Security Council resolution and not required to hand over any individual to the court? I suppose really the question is, quite apart from the immunity, there is no obligation to hand him over. Carry on from that.
Actually, let me turn your question around. So your question was whether the non-state party is obliged to arrest him. And my answer to that question is no. The non-state party has no obligation, neither under the statute nor under the Security Council resolution. More interesting, I think, is the question of whether the non-state party is permitted to arrest President Bashir. The non-state party allowed to arrest him because under international law, ordinarily Bashir would have immunity from arrest in another state, right? And the argument would then be, is there anything that removes that immunity which allows the other state, non-party, to arrest Bashir? And my response to that is actually yes, that the Security Council resolution, whilst not obliging Bashir, non-state parties, it permits it, because the effect of it, by imposing that jurisdiction, is to remove that immunity, pursuant to the argument that I made in relation to Article 27. But it doesn't create an obligation.
So whether they'd actually be permitted would depend on their domestic law.
That's right.
There is a permission in international law. Do you want to add anything
I'm not,
to that?
I'd agree with Dapo, but I think there's another way of looking at it altogether, and that's the nature of the crimes. I mean, these are international crimes to which immunity doesn't apply. Genocide under the Genocide Convention, no immunity.
Yes. Sorry, that's controversial. But
Geneva
carry on.
Conventions. I'd say it's as their status of international crimes that immunity is stripped away, potentially.
Okay, Dapo, do you want to respond to that one?
Yeah, so that was the question that the ICJ dealt with in the arrest warrant case.
Yeah.
And the ICJ said no, even though it's an allegation of an international crime, the immunity remains for this group. It's a narrow group we're talking about.
It's serving heads of state, yes. Serving officials. Okay, moving on. Yes?
I was just wondering generally.
Sorry, introduce yourself. Thank you.
Dominic Bright, law student. I was just wondering if the Italy-Germany judgment in the field of public international law might impact. I mean, how do you think it's impacted, or will it impact on international criminal law? And do you think international criminal law and public international law, the way they deal with immunity, is going off on tangents?
Thank you. Good question. That Limp judgment, Dapo, do you want to mention anything about that Limp judgment?
Yeah, so this is a judgment in an interstate case which dealt with civil claims, and the ICJ held that there was immunity for the state, so they were talking about state officials. I mean, I suppose it links back to our last point about whether the immunity is removed because of the nature of the offence. And in that sense, that judgment goes together with the arrest warrant case in saying that the fact that it's international crimes doesn't necessarily mean that there's no immunity. What's interesting, just to go back to the ICC's decision, pre-trial chamber's decision, this is one of the things that I found actually most difficult about it is that they weren't basing their decision on the nature of the crimes. They were basing it on the nature of the tribunal. So assuming that it was an international tribunal to do with cocoa smuggling, there would likewise be no immunity. This is why I call it the nuclear option, you know.
I always give my students the example of the European Court of Justice decided to take criminal jurisdiction over all sorts of petty crimes. Would they then be able to extend their... Yeah. Anyone else for the moment? Yes, Chris, we're coming back to you.
Okay. Dapo, you mentioned paragraph 60 of the arrest warrant case, one of the most highly criticized judgments of the International Court of Justice, in which they rather boldly said that Belgium had failed to prove an exception to a rule that they hadn't proved existed of immunity. And also, the other thing is you overlooked paragraph 61.
Now, Chris,
Yes. Which said,
let's not go too much into the details of the paragraph numbers, if you don't mind.
But just in terms of
Sorry.
immunity, where the court said very clearly that international criminal courts would have jurisdiction. And the other thing is that if you look at the instruments that were cited in the opinion, which follow very closely the argument that Amnesty International made, they all were accepting that they were, it wasn't simply a criminal responsibility issue, but as Eichmann pointed out in its analysis, in the Supreme Court, and Eichmann pointed out in its analysis, it was also dealing with immunities. And it was also, the instruments were designed to reflect international law applicable in national courts. And if you look at the history of the International Law Commission drafting of the Draft Code of Crimes, it's very clear that this was an international law rule that applied both to national courts and to international courts.
Thank you very much. Dapo, you have 1 minute and then we're going to drinks.
Just to say that you're right, the International Court of Justice in the arrest warrant case did say that there was immunity before certain international criminal tribunals, but it's a very broad and vague statement, and they refer to Article 27 of the ICC statute, and of course to those provisions in Nuremberg and the ICTY. But that doesn't answer the point that I made, that in relation to those provisions, the instruments in question were binding on the states with respect to which they were being applied. The ICJ didn't say anything about whether an international criminal tribunal would have jurisdiction over non-parties. In fact, because they said there's no immunity before certain international criminal tribunals, it almost forecloses what the ICC said, that there is no immunity before any international tribunal. The ICJ statement makes no sense to say there's no immunity before certain international tribunals if there is no immunity before any international tribunal.
Thank you very much indeed. Please join me with thanking our speakers for a very rich and dense evening.